welcome in our lesson number 8 and our final lesson in our construction claims management and EOT delay analysis course. In this lesson we just want to put some light on the contracts, and I have divided this lesson into 3 main parts, so to make the lesson simple and easy to understand. First part, we are talking about general concepts and talking about the contracts itself. And in part 2, we'll talk about the FDIC, what you need to know in the FDIC. And the last part, which is very small, talking about the claims and disputes under FDIC. So let's go and start with part 1. Contract is one of the most important references you need to refer when you are raising a claim. Therefore, we need to understand what are the contracts and their types. In this lesson, we will simply explain the contracts for whoever don't know the background or don't have a contractual background of common contracts and how you can deal with them. Introduction about contracts and contractors types. This is our agenda for part 1, so let's go and discuss it immediately. First of all, you need to understand the different parties involved in any project. You have too many parties could be in any construction project. For example, the employer, the contractor, the professional team, the engineer, and here we could refer it as a consultant as well. Subcontractors, and the subcontractor could be nominated by the client to you, or you choose your own subcontractors. Employer's agent or project manager, the employer could assign an organization or a person as a project manager. This could be different from the consultant or the engineer. Funder or sponsor of the project, and they could have a role also in the project. So these are the main parties that could be involved in any construction project. The relationship between these parties cannot be defined because it is varied from a project to another. However, there is a level of power you should consider or taking into your consideration, that the client or the employer is the first priority, or he have the power, the most power on the project. After the client or the employer, the engineer power came, then the contractor, then the subcontractor, and so on. So you need to know in your project what is the power and of the individual stakeholders, or we can call it organizations or parties involved in the project. What is the contract? I don't like actually the narrative about contractual issues, but I put here some simple definition for you to understand that the contract is an agreement made between 2 or more parties, which is enforceable by law to provide something in return for something else from the second party. The 2 parties are expected to perform various obligations they have undertaken as expressed in a mutually agreed set of contract documents. So in order to know what the contract says, you need to know the contract documents. And there is a strategy for the contract you need to understand as well. The contract strategy means selecting organizational and contractual policies required for the execution of a specific project. The development of the contract strategy, it is almost or usually done by the client. So he do his own strategy for establishing a contract, but you as a contractor, you should read what you will execute and what you will agree to do, because the contract is a legal document. So the contract strategy should have the following: setting the project objectives and constraints, selecting a proper project delivery method, selecting a proper contract form or type, we'll talk about this later on, and contract administration practices. So this is the steps, you can call it steps as well, of any contract. So do you think all the agreements are contracts? Let's see. The contracts should have legal standing parties. It means that two or more parties, they should have a certain legal standing in order to make a contract. And proper subject matter. You cannot make a contract that violates the law. So that your contract should be aligned with the law in your project country. Consideration. There must be a lawful and valuable consideration given for both parties. In other words, something for something. I will build this project and I will get this money. This should be defined in a contract. Without this definition, this is not a contract. And finally, the agreement. So both parties must wish and intend to enforce this agreement and be bound to it by the law. So the agreement actually is part of the contract and cannot stand as a contract itself. So let's talk about the proper form. The terms of the contract must be written so that both parties are very sure of what their rights and responsibilities are. One more thing about the contract or agreement, that the agreement must be free from mispresentation. It means that both parties sign this agreement without any force. The contract need. Contract provides a description of responsibilities and liabilities. The contract binds parties to their duties. The contract can establish a time frame for duties. The contract can secure payment. The contract can provide resources. So these just points to be considered while you are reading a contract. Now let's talk about the contract documents. What are the contract documents? We have here the agreement for general condition, special condition, and this is almost fixed for any construction project. However, we have some additionals now we'll talk about them, which includes the following. Contract agreement. This presents the final agreement document that is signed by both parties and contains the full detailed information about them. Letter of tender. This letter of tender is completed by the contractor and contains a signed offer to the client. So a letter of the tender is signed by the contractor, sent to the client, telling how much time and cost this project will cost. Letter of acceptance. The letter of acceptance is the letter sent from the employer to the contractor, including any annexed attached agree between both parties. It means in that case that the client agreed to award this project to the contractor. We have the condition of the contract. There is a special condition of the contract and general condition of the contract. We also might have a specification for the project and drawings and program. Means document entitled schedules completed by contractor and submitted with the letter of the tender. It should be included under this section. This section also could have bill of quantities, list, schedules, or any rates or any prices. This is how they struct the contract contents. Contract documents power. I know we talked about this in our previous lessons, but we will recap here about the power of each document and its priority. Mainly we'll have something like 7 documents in any traditional project. Contract agreement, letter of acceptance, the particular condition of the contract, general condition of the contracts, drawing, specification, bill of quantity. As we said before, you need to know the power of each document. So, when you are preparing a claim, you should consider taking into your mind the power of your contract documents. Construction contract forms. There are forms made by international organizations that includes the most common terms and conditions and clauses for the construction. Some forms, contract forms, is the FIDIC is a contract form, and NEC it is another contract form. So what mean by contract form is the produced product by a certain organization or a certain structure that both client and contractor will agree to follow. Contracting process. Any contract, it passes through different stages, from identifying project, prepare scope, selecting contract, then inviting tenders, tender meetings, tender evaluation, then place contract. And the contractor should prepare the tender document. So all the above except prepare tender document is from the client, and only prepare tender document is from the contractor. Type of contracts. I would like you to know the common type of contracts, and we will focus on the most common type of contracts. There are two types of contracts, cost-based and price-based. Cost-based, we have two different types of cost-based contracts. Cost plus and target cost. Actually, are not very common in the construction industry because it has high risk. But I will explain to you here what the meaning of the cost plus and the target cost. Cost plus means you as a contractor will take a fixed percentage for each dollar you spend on the project. Let's say you spent $100,000 and your percentage is 10%, so we'll take your 10% from as an overhead and profit from whatever you already executed on the project. This is high risk contract for the clients, but it is of course very low risk for the contractor. Then they develop this cost plus contract to another term called target cost. It means that the client and the contractor will agree about a certain amount to execute this project. However, if the contractor succeeded to execute the project with less amount, both client and contractor will share the profit with a certain percentage, which you call win-win situation. On the other hand, if the contractor failed to finish the project with this specific amount, he should pay some of the additional cost and the client will pay the remaining amount. The most common contract types in the construction projects are the price-based contracts, which is divided into two contracts type, unit price and lump sum. We will carry on and discuss these types in details. The unit price contract is a tender price. It has a contract value with tender price, but can be increased according to the actual quantity executed. The payment is paid monthly for all work completed during the month or any duration agreed. However, this type of contract allows some design changes because there is no harm on the contractor to execute the additional work, since additional payment for any changes in the work can be guaranteed. This contract is best suitable for repetitive work and the variation not limited. Additional payments can be made according to increase of the BOQ quantity. This type of contract associated with high risks to the client but low risks to the contractors. The opposite here is the lump sum contracts. Lump sum contracts mean that both client and contractor agreed to execute this work with this amount. However, if the executed quantity exceeded the BOQ quantity or was less than the bill of quantities, the contractor will be paid only the amount in the bill of quantity. So the contract final price is known at the tender stage. It has high level of risk in the contractor and low level of risk for the consultant. However, the changes here is very limited because any changes will be subject to variation orders. This can be used in the turnkey construction and for to transfer the risks from client to contractor. Construction claim reference to the contractor. Construction claim. A construction claim is a request for payment or time extension to which the contractor consider him or herself entitled under the contract condition and terms. There are three types under which claims are required: extension of time only, additional cost, or both extension of time and additional cost. So the claim could be for time or for cost or for both. The legal system could be civil law or common law. Civil law means the law of your country, and common law could be previous cases similar to your case, so the court can go to these legal systems. It's depend on the country where the project refer to its law, and whether they are going to use the civil law to finalize any claim or dispute, or they are going to find similar cases which called common law and follow what was done before. For Egypt, for example, we have here the civil law and we have administrative law. And administrative law, we have three laws under it. So according to your country, if you entered a dispute, you need to know which law you are going to refer when it reach to the dispute stage. Of course, you can solve any problems during the project as a claim, because a claim, it is not a problem. You can be solved between the contractor and the client. However, if it reaches to the dispute, it means it is a case and need to be go to the court. We finish this part and we continue to the second part, which is the FIDIC. I kept for you these PDF files so you can read it at your own, and of course we can use our forum for any discussions and questions regarding the whole course, not only this lesson. So let's go and see what the second part say. In part 2, we'll start talking about FIDIC. So what you need to know in FIDIC. Let's go and start talking about FIDIC in general. Part 2 and part 3 of our lesson today, it is better to read it yourself, but I will just highlight what I want you to know in these parts. First of all, FIDIC, you need to know that the FIDIC now covers more than 99 countries in the world. They are using the FIDIC as the legal form of contract. So it has become recognized internationally, and therefore we dedicated a special part for it, because your contract, even if it is not referring clearly to the FIDIC, they are copying clauses from the FIDIC and putting in your contract. FIDIC RIMPO. FIDIC created a different box and different versions of the FIDIC. The only difference between these box are the risk allocations. So you need to know when it is someone telling you red book or silver book or whatever color book, it is all about the risk allocation. And I attached to this lesson a link from the FIDIC website. they are explaining what is the contents for each book. I'll now tell you in brief what is the main differences between books. The green book is for straightforward, quick or cheap projects, less than $500,000. So the FIDIC is suitable for such kind of project. The red book, and this is the most common book we are using in our construction, this is for employer design, and this is traditional book. The pink book, it is employer design, but it is financed by development banks like international banks or whatever. So this is dedicated for such projects. Yellow book is contractor design. So if the contractor take the project design and build, this could be yellow book. We have another chart after this slide. Will explain exactly what is the difference and how to know your project will fall under which book. There are two different colors now remaining. Silver book, this is for turnkey projects, and gold book, design, build, and operate projects. If the contractor will operate the project, like the metro projects or electricity stations projects, sometimes the client asks the contractor to operate as well. FIDIC rainbow. Actually, this chart is very nice and very simple. It's explained to you what you should use in the FIDIC by answering yes or no question. So the first will start from here. Is it a straightforward project? If yes, then you can use the green book. If no, you have to answer the second question. Is it employer design? If yes, so you can go directly to the red book. If no, you have to answer another question now. Contractor design. This is for plans or high unforeseen risks. If you have maintenance, then you will go to the golden book. If you don't have maintenance, you go to the yellow book. However, if you have a fixed price, lump sum, little employer involvement, no major unforeseen risks, then you can use the silver book. Or if no, you can discussion in details, you need a further discussion. So this simply explain to you which version of the FIDIC you should use in your project. Of course, when you reach to the project stage, by then you know which version of FIDIC you are using, because it is written in the contract. But this is how they decide to use which version of the FIDIC. FIDIC general condition and the clauses. I will keep this for you to read it, but I just want to highlight that there is 20 clauses and there are 193 sub-clauses. You will see here the clause and the clause title. This will give you a good understanding when you are looking for something where to go. So you can download this PDF file and you can see here all the clauses with its titles, so you can find easily the relevant clause in your claim situation. The obligations. We want also here to highlight the obligations in the FIDIC, under FIDIC. The obligation for the employer, the obligation for contractor, the obligation for engineer, and the obligation of DAP. So here also I put for you what is the clauses in the FIDIC which talk about the employer obligations. You have here the clause number, and you have here the obligation and the time frame, if there is time frame, and the consequences of non-compliance. So if you are contractor and you feel that your client is not committed to the obligations, you can refer to the consequences or the non-compliance. So this also for you, no need to read it because you will go to it when you need it only. This is the employer obligations, and after this one you will find the engineer obligations, and finally the contractor obligations. This is, I prefer to keep it with you. That's why we separated this part, because you can print it, put it in front of you when you are preparing a claim, and you can find easily which clause you should read in your contract to find the relevant clause or relevant obligation to refer to your client, to refer it to your client. So this is the employer and contractor and consultant, or the engineer. Here the engineer means the consultant. Of course, as I say usual, if you have any discussions or questions by this stage of the course, you are welcome to post it in our support forums, and we'll be more than happy to answer it. Just I want to now, before ending this video, talk about the last part, which is part 3, and it is very simple. Let's go and see what it says. Part 3. Part 3 is about claims, disputes, and arbitration under FIDIC. We just want to highlight that the FIDIC form including a fair risk allocation, and it gives clear guidelines for the process, or how to raise a claim and how to communicate with the other parties when it comes to the claim. So this simple chart you may see before in our previous lessons, but we want to recap on it, that you have 28 days to submit a claim notice, and you have from the event date 42 days to submit a detailed claim. And please be careful here, because if you don't have the claim details, fully details, you should notify the client or the employer that the details are not available because of 1, 2, 3, 4, 5, and this should be submitted when it is available. For example, you could be waiting for a response from a supplier for the new prices of the new materials, and in that case you need to extend this duration in writing, because we'll see later on what could happen if you don't do this. And the engineer should respond to you within 42 days or any approved duration by you as a contractor. You need to remember that when we reach to the dispute, it means we finish the DAB, we didn't reach any amicable settlement, and in that case we are going to the arbitration. So when dispute raised, dispute means that you and your client, you as a contractor and the client, cannot find a way of understanding to finalize all the disagreement. And then if you have a DAP in your project, assigned DAP, you have to go to the DAP, and if you didn't succeed to finalize the claim or the dispute, now it is not a claim, it's a dispute. If you didn't succeed to solve it in the DAP, you have to try the amicable settlement, mutual agreements, and you cannot go to the arbitration, which is the last stage, before spending 56 days on the amicable settlement. So this also should be considered when you are preparing a claim. And the claim refuse, the employer may present various arguments and objections which may be defendable or non-defendable for you as a contractor. Defendable refuses, the client could reject your extension of time because the relevant activity does not lie on the critical path, so no AOT. This is not a reason. You can, although the activity is not in the critical path, but you should prove to your client that it burns all the floats and became critical by such and such causes. So also the client can argue with you that you are an experienced contractor and you should see these risks or unforeseens, and you have to prove to your client or consultant that you have already some calculations and this risk exceeded the calculation. This is the best way to cut it short, and you cannot expect this unforeseen because it was because 1, 2, 3, 4, 5. You have to explain to him. However, what I want to highlight here, the non-defendable refuse, the claim notice was late or the preliminary notice was late. You need to submit the notice on time and you submit the claim itself on time. You have to notify the client officially by a letter that there is a claim, and this is before 28 days after the events happened. Claim notice. The contractor should only consider himself entitled for a claim if the first step was given to the client, and this is subclause 20.1 in the FDIC. So you need to be safe. Don't forget to submit the claim notice. It is very important. And the reasons they are making this claim notice very important because you are giving a notification and making everyone on the project aware that there is a claim, and they could mitigate any risks associated with this claim, or they could waive the claim itself. And in that case, you showed the good intention and you fulfilled your contract. The clause 20 is very important for claims. This is what talks about construction claims, and there are some sub clauses in this clause. I type it here for you for your reference, because if you are preparing a claim, you might need to know where to find relevant clauses to refer in your letters or your narrative or whatever. So the clause 20 is very important, and we here listed the sub clauses of this clause. I advise you to download or to purchase, if you have the FDIC 1999, the clause 20 to be in your office. This is important if your contract is under FDIC and you want to send a contractual letters or contractual documents to your client. As we said before, we reaches now the end of this course. I hope you find it useful for you. We will keep improving this course by your feedback. Actually, this module itself is a result of your feedback and as a request from our trainees, so we prepared it for everyone. So please, if you have any questions or any ideas or doubts, you are most welcome to post it in our support forums, and we will do our best to always be a professional with you and give you the information and the knowledge in a very simple way. Thank you very much, and I wish you enjoyed this course and this lesson, and I wish to see you in future courses. Thank you very much, and see you again.